F around and find out. That's where we are. We are in the sort of ultimate culmination of F around, find out. F around and find out by making up lies, by making up statements that have no basis in fact, or at least that you aren't willing to provide receipts for, or haven't been able to provide receipts for because judgment against you. So the short version of the facts are this. On her internet webcast, podcast, YouTube, whatever, Yax accused Andia Chera, who is a healthcare provider in her own right, of committing bribery and contributing to the untimely deaths of Ray's son and one of the patients. These statements, false, defamatory, unprivileged, actionable, and highly offensive, meet the standards set forth in Mississippi law for defamation, specifically slander and false slight invasion of privacy. Yeah, you can't make up things about people. You can't just say things. You can't just say things like this woman did these things with no evidence or no proof, or at least none that you're willing to provide, none that the court is aware of. Each statement was made with actual malice, that is, with knowledge that was false or with reckless disregard. So the court held evidentiary hearing on damages in May. Andia Chera, for her part, testified under oath about the harm that Yax's false statements caused her. She confirmed for jurisdictional purposes the relationships those statements had with the state of Mississippi. She then provided as a point of reference a decision by Judge Sampson awarding $75,000 to a victim of defamation. Yax did not appear at the hearing despite the court's express invitation, which is unfortunately not the first time that Yax has not shown up. She has not participated throughout this proceedings. She has been repeatedly not showing up and repeatedly not participating, refusing to take phone calls, refusing to show up for hearings, and just not participating, which, is not really an option. When there's a case going on against you, you can't just not participate and hope it goes away. That's not really a viable option. Because this case is proceeding in diversity, because, two different states, the applicable substantive law is that of the forum state. State law is looking by decision of the state's highest court, which, exactly what you would expect, right? A federal court, when applying state law, has to apply state law. So what does it do? It looks to the highest law that's available. So it's going to look to the best law that's available to try to figure out what Mississippi wants. So let's just do what Mississippi wants. Okay. In Mississippi, compensation damages are such that damages will compensate the injured party for injury sustained and nothing more, such as will make simply good or replace the loss caused by the injury. So compensation are just, what did you lose? And give it back. Damages for emotional distress alleged in connection with intentional tort may be recovered even when the plaintiff has experienced no physical injury. Your loss can be emotional. Your loss can be things. It could be stuff. It could be physical harm. It could be emotional harm. What will compensate you for the loss? So emotional harm, sure. The standard considers whether defendant's behavior is malicious, intentional, willful, wanton, grossly careless, indifferent, or reckless. In those cases where mental or emotional stress is a foreseeable result of the conduct of the defendant, a court can assign damages for mental and emotional distress. Because Yak's statements imputed the guilt or commission of some criminal offense involving moral turpitude, such as, you tried to bribe witnesses to not cooperate and stuff, and infamous punishment, and imputed a want of integrity or capacity, whether mental or pecuniary, in the conduct of the profession, trade, or business, they are actionable per se and need no special harm. Defamation per se goes to your professional reputation. The Speed Court, for example, knows that being called a thief can be actionable per se because a crime like thievery is a significant criminal act. It points to a different case in which a Mississippi juror awarded cash $5,000 for slander after a manager falsely accused her of stealing $1,000. To place those sums in conduct, the U.S. Bureau of Labor Statistics says that $5,000 of 1917 has the same buying power as $130,000 today. So just to adjust for inflation. In this case, Andia Chera testified about emotional distress that Yak statements cause. For a parent to be accused of contributing to their child's death is its own kind of pain. I would imagine that would be quite distressing on a lot of levels. Having that broadcast to thousands of people amplifies the pain. Knowing that tens of thousands of people have watched Yak's false statements, Andia Chera says, makes you very paranoid. It makes you very uncomfortable in public. You don't know who's listening and who's believing what she's saying, or who knows what she's saying is crazy. And so you do become very isolated and you don't go out to eat. You don't go do things that you normally did because you don't know where everyone stands that's around you. The court heard testimony about how Yax profited from her false statements. Perhaps the worst part, Andia Chera says that Yax offered to share Andia Chera's son autopsy photos with strangers on the internet, which caused perhaps some of the most upset just knowing that people you had to know these pictures of where he's naked and cut open and all that. Andia Chera explained at length the effects that Yak's statement had on her life and her community. After the webcast, people filed complaint with Andia Chera with the Mississippi Board of Nursing, which opened an investigation and found nothing. So people believed it to the point that they filed complaints against her in her profession. People called her employer. They accused her of embezzlement via complaints with the Mississippi Secretary of State, which commenced its own investigation and found nothing. For a sense of how baseless the allegations were, listeners even accused Andia Chera of overprescribing opiates, a class of drugs that Andia Chera does not prescribe. Some people believed Karen Yax and started taking actions based on the things they heard. They believed the lies. and started doing things on the basis of the lies. So guess what? You're a little bit responsible for that, you know? So, you can't just make up shit about people. And then people, it's like, I'm not responsible for what other people do. You are a little bit. Yeah. You're responsible for a little bit of this. The court finds Andiachero's testimony compelling. The mental and emotional toll of Yax's false statements have taken on Andiachero was obvious at the hearing. Being accused of bribing a witness is one thing. Being accused of contributing your own child's death is another. Yax's false statements cause real harm and warrant damages. The above cited case on emotional damages in Mississippi reveals a range of damages granted in a range of situations. The court has also looked at a different decision in Mississippi, which reinstated a jury's verdict of $500,000 in compensation for severe emotional distress. The calculation of damages cannot be reduced to a mathematical formula, which, reasonable enough, because the issue is always how much have you been hurt? So how much other people have been hurt in some situations is at best informative, right? Because the issue is how much you've been hurt. So if someone else has been hurt to the tune of these numbers, that's at best informative of what might be true in some sort of comparable case. But it's not reducible to a simple formula. The plaintiffs, like defendants at criminal sentencing hearings, are individuals that must be treated as such. Fair, justice should be based on what the individual has done. For that matter, no sum of money can make a truly harmed person whole. Finders of fact are nevertheless obligated to determine a dollar amount to approximate that goal. And relevant cases illustrate ranges from which reasonable damages can be discerned. So, therefore, based on all this, the court believes the evidence supports an award damages between those identified in various cases and assesses compensation at $325,000. The next issue is punitives. The court has been mindful of case law indicating that Mississippi fact finders err when they're influenced by egregious, outrageous, and obviously intentional nature of conduct to award compensation damages that are penal in nature. Punitive damages, rather, are the means by which they may be punished for the egregious nature of the conduct. They may only be awarded when the plaintiff proves by clear and convincing evidence defendant acted with actual malice, gross negligence, which evinces a willful, wanton, or reckless care. They are the exception rather than the rule. So the court is noting a couple things, okay? Compensation damages are merely to compensate, not to punish, right? So the court is taking note here that you should and must be cautious to not award compensation damages that are really punitive in their nature, because that's not what compensation damages are for. Compensation damages are merely to compensate how much you've been harmed. If punitive damages are appropriate, then they should be awarded as punitives, but you shouldn't conflate the categories. That's what they're talking about, right? So don't award compensation damages that are in fact penal in their nature, which is to say punitive. Make sure to keep the categories separate. Punitive damages are for punishment. Compensation is for compensation. And then notes that this is a higher standard and only for the exception rather than the rule. So it's not something you should do every time. It's only in cases which meet this higher elevated standard. The egregious nature of Yax's false statements warrant punitive damages. Yax's outrageous accusation that Andiachero contributed to her child's death likely means the definition of malice, but at minimum warrants punitive damages because it was made with reckless disregard, and the court sets punitive damages at $165,000. So $325,000 plus $165,000, well, and then awards attorney's fees of $11,000, bringing us to $500,000. So $500,000. The last issue is the attorney's fees. Counsel seeks $11,000, which is calculated by taking his hourly rate and multiplying by the number of hours he expended. The court finds this sum justified by its evidentiary predicate. For these reasons, $325,000, $165,000, $11,000, which is well, technically, let's see, that's 6, so that's 8. So that's technically $501,000. So, okay, $501,000. So, yeah.